Hi, I'm Jen, and I'm an account manager with Hello Divorce. Welcome to our comprehensive guide on the petition for divorce, a key component in the Washington divorce process. For those using Hello Divorce, we offer a streamlined experience. We'll guide you through each step, simplifying the legal terminology, auto-generate your forms, assist with filing, and provide access to experts for additional support. However, this video is beneficial for anyone navigating a divorce in Washington. So let's dive in and together demystify the petition. This is Form FL Divorce 201, the petition for divorce, also known as dissolution. The petitioner is the person who starts this case, and the respondent is the other spouse. The petition is the petitioner's requests to the court, and in the same vein, the respondent is able to file a response to their own requests to the court. Just because something is asked for in the petition or response does not mean that the court will automatically grant it. The parties will have an opportunity to come together and come to an agreement. In this form, it will ask you about general information regarding you and your spouse, like where you live, where and when you were married, and whether you still live in the same house. The next part is regarding whether the court has jurisdiction over the marriage. If the court does not have personal jurisdiction over the respondent, then it may limit the court's ability to divide property, award money, set child or spousal support, or approve a restraining order. Next, there is a request for the divorce and a date for when the marital community ended. The name change is for whether the spouses decide to change their name back to their name prior to the marriage. Please keep in mind that if your spouse is the respondent, they must agree to the name change. The written agreement section is to let the court know whether you and your spouse have signed a prenuptial agreement. This is also known as a prenup, a separation agreement, or a community property agreement. If you have questions on whether your agreements are enforceable, our Washington legal technician can help you with legal advice. For real property, personal property, and debts, you can check any of the boxes, but generally speaking, parties can also let the courts know that they are trying to reach an agreement in the other section. The spousal support section allows for you to ask for spousal support or to let the court know that it's not needed. You can also request any fees or costs, a protection order, or a restraining order in this process. The next section is regarding children that you and your spouse have together, biological and adopted, including whether one of the spouses is pregnant. Include dependent children. This is generally for children under the age of 18 or for children over 18 but are still dependent, such as special needs children. You will need to fill out where the children have lived in the last 5 years and whether other people have the legal right to spend with them. If there are court cases that involve a child, then it should be disclosed to the court. The court then has to determine jurisdiction over the children and whether it can approve a parenting plan. There are numerous ways that the court can approve jurisdiction over the children, but there may also be instances where the court does not have any jurisdiction over children. The parenting plan can be included in the petition, or it can be filed in the divorce process before the divorce ends. Next, there is a section regarding child support and what expenses the party is requesting their spouse to pay their share of. Lastly, there is a section regarding children from other relationships. One last important part of this form is the joinder. This allows the respondent to join the petition and thus can bypass any service requirements and can make the process a little bit smoother. By signing the joinder, the respondent is acknowledging that they understand that the court can approve the requests listed in the petition unless the respondent files and serves a response before the final orders. The respondent also has the ability to choose if they would like to be formally notified of the court's hearings or decisions, or if they do not need to be notified. I hope you found this video helpful. We have a variety of resources on our website, hellodivorce.com, pertaining to all things divorce, including what we went over in this video. If you need help with your divorce or have any questions, you can also schedule a free 15-minute info call with our team on our website. Thank you.